defendant today is the EPA, and the EPA is the enabling governmental agency that allowed this to happen in the first place. The USDA and the CDFA will also be defendants in up-and-coming lawsuits. The issue here is the pesticide that was sprayed on the people of Monterey and Santa Cruz was claimed to be safe. It was unsafe. The EPA exempted Checkmate from their normal process of approving pesticides. What's happened with the EPA is unfortunately what's happened with a number of federal agencies. The agencies are supposed to regulate industry has been captured by the industries they're supposed to regulate, and the EPA is the prime example. In fact, the industry has pretty much captured the management of EPA and allowed this to occur.
Now, the Moth is, the farmers' agriculture businesses. They say this could devastate, farming in this part of the state, and they say that they have done tests and things that this is safe. And why you don't think that?
Oh, absolutely, it's not safe at all. In fact, we're gonna prove here in the court that it's not safe. I was in the courtroom in Monterey back in April when the judge held a trial and issued an opinion down there. And the fact was there was no emergency. This light brown apple moth has done no damage to crops in California. This whole thing is about money. It's about the California Department of Food and Ag implementing their budget with $500 million of Homeland Security money. And if you follow the money, you're going to see why this all took place in the first place.
We are here this morning at the U.S. Federal District Court in San Francisco to file a landmark lawsuit against the U.S. Environmental Protection Agency. We are here to ask the courts to declare unlawful EPA's exemption from registration of the 2 pesticides that were sprayed indiscriminately on tens of thousands of citizens of Monterey and Santa Cruz counties in the fall of 2007. Those pesticides are harmful both to humans and to wildlife. During the spraying between September and November of 2007, over 650 seabirds were killed. Hundreds of other wildlife, including domestic pets, cats, dogs, rabbits, hamsters, goldfish, were killed. Honeybees experienced a significant die-off. Over 600 individuals filed written claims with the state of California reporting illnesses and injuries ranging from rashes and eye irritation to near-death loss of breath due to reactive airway disease and asthma. Among our plaintiffs are 2 children, an infant, Jack Wilcox, who was only 11 months old at the time, who stopped breathing over and over again. While he was rushed to the hospital and administered emergency treatment, he now faces a lifetime of dependence on medications to keep him healthy. Another individual, a 10-year-old child, Nora Aaron, also nearly died on the way to the hospital. She was in Santa Cruz. Before this incident, she was a blossoming athlete, very delightful to watch, and a real powerhouse on the playing field. Subsequent to this, she has had to change her career plans. She has asthma now, so her life has been altered forever, as has Jack's. Those are but 2 of hundreds of people who were severely and adversely affected by this spraying. What is particularly pernicious about this was not a program by agribusinesses over fields that they owned. This was a program administered by the state and federal governments, ostensibly to protect us from a so-called pest that to date has caused absolutely no documented damage to any agricultural crops in California. The U.S. Department of Agriculture, coupled with the U.S. Environmental Protection Agency, deemed these pesticides safe, even though they had not been tested with respect to all of their ingredients. Several of their ingredients, the so-called inert ingredients, were in fact highly toxic to fish and wildlife, to seabirds, and indeed to humans. In addition, the California Department of Food and Agriculture led the way with this improvident, widespread, indiscriminate, and unstudied spraying on tens of thousands of citizens throughout those counties. They were used in effect as guinea pigs for a broad-scale experiment on the human health effects of untested pesticide ingredients. Last month, the California Department of Food and Agriculture and the Department of Pesticide Regulation issued 2 reports on the spraying 1 year after the spraying was conducted. Instead of studying the toxic effects before the spraying was authorized, they came in after the fact when it was too late to protect those individuals who were harmed. Not surprisingly, their studies, even though quick and dirty six-pack studies that don't look at long-term effects, don't look at subtle effects, don't look at disruption of endocrine and hormonal processes in the body, nonetheless found significant harm, liver and spleen and lung damage in all of the test guinea pigs. 10% of the guinea pigs died. So 10% mortality is not safe. It is extremely hazardous. One of the ingredients, TMAC, trimethyl methyl ammonium chloride, is in fact known to EPA to be harmful. The material data safety sheets for this product state on the label it is harmful when inhaled, and it is so toxic it will burn the eyes and the lung and the esophagus if ingested. So this is a chemical known to EPA to be harmful, and it should have been known to the California Department of Pesticide Regulation and to the California Department of Food and Agriculture as a substance not to be sprayed. In fact, TMAC's adverse impacts on the environment range far broader than those immediate acute impacts on lungs, spleens, livers, eyes, throat. It is also a surfactant, which means it has detergent qualities, and it's those detergent qualities that stripped the natural oils from the feathers of seabirds by the hundreds in Monterey Bay, causing them to flounder and die because they were no longer insulated from the cold of the seawater, and they had also lost the buoyancy that those oils naturally confer on the feather covering of those birds. So here we have a broad-scale, indiscriminate spraying of pesticides known to EPA to be harmful with utter disregard for human health and safety and environmental protection. We are here today to ask the federal court to right this wrong, to declare that EPA's purported exemption of these pesticides from registration was unlawful, and to set a precedent that will protect the public and assure that this tragic event will never recur.
Are you the lawsuit itself? Are you asking for damages for these folks, or what? A restraining order to stop any future spraying, or give us some of the specifics of the lawsuit?
Yes, I will. This is not a lawsuit for damages. That is a separate process. As an aside, those most critically injured by the spraying have filed damage claims with the state of California. Each and every one has been denied without analysis. And 2 of the families have asked our firm to file lawsuits for damages against the state of California, the Wilcox family and the Aaron family, because of the long-term significant harm to their children. This lawsuit is in federal court asking a federal judge to order the federal government to comply with the law. And we will ask for injunctive relief should it become necessary. We believe the court will rule, as the law requires, that this spraying was unlawful, that EPA could not exempt these pesticides from registration, And if they are required to be registered, they will undergo the kind of detailed, exhaustive, comprehensive testing on the human health effects, on the long-term effects on the environment that should have been done, and that had it been done, would have shown that these pesticides are harmful and not safe for human use.
So the state agricultural department, obviously, before they started spraying, said that this was safe and that they'd done tests, and that the brown apple moth was a huge threat to the agriculture industry in this state, and obviously you disagree with that.
The facts belie both claims. When the state of California was hauled into Superior Court in Santa Cruz and Monterey counties, both courts in March and April of 2008 ruled unhesitatingly that the State Department of Food and Agriculture had utterly failed to show any documented damage to agricultural crops in this state. Let me talk a bit about that. The state claimed that there was an explosion of light brown apple moths in the summer of 2007 because early that year, I believe it was in February, a retired entomologist in Berkeley who had a blacklight trap in his backyard happened to find 2 of them. It's not as though scientists everywhere were looking for them for years. He found 2. On March 1, the state put some traps out in Alameda and Contra Costa County and found more. And over the ensuing months, more and more were found in Santa Cruz, Monterey, Santa Clara, San Mateo, San Francisco, Marin, Sonoma counties. It shouldn't come as a surprise. The apple moth has been in California for at least 30 years and perhaps as long as 50 years, according to Dr. James Perry, an entomologist at UC Davis, who is an expert in the migration and reproduction of insects, including the apple moth. Because of their distribution over that wide area of California, he concluded they must have been here for many decades. This is a moth that only travels up to 100 yards in its lifespan. It only feeds when it is in the larval form, by the way. So it only feeds when it's in the host leaf, and it feeds lightly. It doesn't attack the fruit. It doesn't strip plants of their foliage. It is controlled, if you will, naturally by other predators in the ecosystem, including insects like wasps. They all eat the larvae when they're young. It's nutritious. In fact, Native Americans used to eat larvae of all kinds of animals. It's high in protein. There's nothing wrong with apple moths. They are part of the natural ecosystem. There is something wrong with these pheromones that attract not only the light brown apple moth, which has been deemed a pest by the Food and Agriculture Department, but other moths and butterflies of the family Lepidoptera that are considered to be beneficial. And if you strip those insects from our natural world, there's no telling what adverse impacts will follow. Just as we've seen a huge die-off in honeybees throughout this country in the last several decades, up to 90%, so too, if we begin pulling the rug out from underneath our moths and butterflies, we may lose the ability to raise our own food. So talk about massive impact on California agriculture. California agriculture depends to a very significant degree on pollination by honeybees. Having grown up in the Central Valley, I can assure you that every spring there are lots of hives throughout the orchards because they do the job. In Santa Cruz and Monterey counties, there were a number of documented incidents where honeybees were dying after a night of spraying. They were found on their sides, on their backs, gasping and dying. There's little doubt that this, like the die-off of the songbirds, the seabirds, cats, dogs, rabbits, and other pets, that was attributable directly to the pesticides that were sprayed everywhere. So we're here today to ask for justice and also to reform the pesticide registration and regulation in our federal and state governments. That it's no longer sufficient for the government to simply tell the public, don't worry, we've looked at it. We don't believe that anymore. We've learned from the 1950s with the indiscriminate testing of atomic bombs, and from a series of disasters with the Medfly spring and so on through the last several decades, that it's not enough for the government to spin a convenient message that cloaks the real truth and masks the adverse impacts on humans and the environment. It's time that the public ask the good questions. They are asking them, and the government now has to answer. And the federal judge will order the government to answer this complaint within 60 days of today of its filing, and we expect to prevail in this action because there is no answer. This registration process was severely flawed in that the government failed to conduct the testing required and ignored its own data showing that TMAC and other inert ingredients were harmful to the environment and to human health.
This pesticide that they said was so controlled through their the planes that dropped the pesticide, the drift, they now have stated that the drift was 17,400 feet. That's 3 1/3 miles beyond the targeted areas. It's unbelievable that our governmental agencies would actually do something like this and think they can get away with it. No governmental agency is above the law. No one's above the law, and we intend to bring them before the judge to have the judge tell them they're not above the law. We're waiting for the draft environmental impact report to be released in late December, early January, and we fully expect them to continue with an eradication program. This will drastically modify their program if we're successful here. Absolutely, absolutely. And in fact, it's an eradication program that's totally unnecessary. Totally unnecessary. You know, they have an opportunity to get $500 million of Homeland Security money to supplement the CDFA budget here in California. Well, they're going to have to find some other way to run their department other than this money.
The agribusiness exploits an understandable public confusion about the meaning of inert. Inert is a term of art in pesticide regulation that simply refers to those chemicals within a pesticide that are not specifically designed to target the pest they're an issue. So that if you have a pesticide that is harmful to humans but is inert for the purpose of attacking a specific pest or bug, then it would be considered an inert ingredient, and thus government and the pesticide industry would typically ignore it in describing the wonders of the pesticide that they're proposing to use. So it is highly confusing to the public, and I think the agencies and the industry deliberately exploit that confusion in suggesting that if something is inert, that it doesn't have the potential for adverse impacts. That's simply not true. EPA was under pressure from APHIS, a department of the U.S. Department of Agriculture, to get on with the business of promoting and protecting U.S. agricultural interests with nary a pause or hesitation to examine the potential adverse impacts on humans and on the natural environment. EPA just rubber stamped the application. The application was devoid of any supporting documentation. This is documented in our lawsuit. So it was a horrendous evasion of applicable environmental laws, resulting in direct injury to hundreds of persons and the deaths of hundreds of wildlife and domestic pets in Santa Cruz and Monterey counties. It's an eco-catastrophe. It's been documented, and we're asking this federal court to set the record straight, to overturn EPA's uncritical exemption of these two dangerous pesticides from the registration process, and basically to halt any further spraying of anything close to these pesticides until we have a full understanding both of the potential short and long-term impacts of these pesticides and of the need for them.
What comes next? What do you think the scenario is, and what will the impact be on policy and practice?
Well, we expect to prevail. And if in fact we do prevail, as Steve said, it's going to change the way the EPA registers, and authorizes pesticides to be used not only in California but all across the United States. What we've seen the past 8 years is the very governmental agencies that we expect to protect us, we expect them to regulate industry, have in effect turned over the management of their agencies to the very industries they're supposed to regulate. And in fact, this is a major problem. We expect the Obama administration to make significant changes in the management of these federal agencies that have caused a collapse of public confidence in them. But in the meantime, we just don't say, you know what, you made a mistake and it's okay. It's not okay. It's not okay. Today's the day of reckoning, and they need to be accountable, and we're going to hold them accountable.
In this case, had that careful analysis required by these statutes been done, the government would have had to turn thumbs down on this pesticide because it's known to be unsafe.
Last a lot of people heard about this story, the state had backed off its plans to use this pesticide against the light brown apple moth. Is it going to change anything for people living in the Bay Area?
Well, actually, a little footnote on that. The state respun its PR or propaganda machine, but it never backed off from its intent to spray these pesticides, the Checkmate and Checkmate-like sprays, in the San Francisco Bay Area. What it said was that it would redraw the boundaries of the spray zones, selecting areas that were forested. Well, if you look at San Mateo County, if you look at Santa Clara, Santa Cruz, Marin, Sonoma, even Alameda, even Contra Costa County, there are a lot of forested areas, and if you hit the forested areas, it means each watershed in those counties will be affected, because all watersheds start at the top of a ridge somewhere. And if you have this pesticide in the drainage, it's going to affect the water courses and San Francisco Bay, and it's going to affect bird life.
So if you prevail in the lawsuit, how does it affect those spray plans?
I would say that it will cause the government to withdraw those plans because they are based on a fundamentally false and unlawful premise that these pesticides are lawful. They're simply not lawful. They've never been registered. They were exempted from registration based on a false representation by the USDA APHIS that they were safe and necessary to address a crisis.
So if you prevail, what they actually have to do, they have to go through some kind of vetting process to register these substances before they can be used?
Yes, a vetting process required under both the Federal Food, Cosmetic and Drug Act and the Federal Insecticide, Fungicide and Rodenticide Act. So these are laws that have been on the books for decades. They have detailed regulations that require public notice, an opportunity for the public to bring in independent scientists to critique the pesticides that are proposed to be registered, and you would see through that process, just as you do typically with an environmental impact report or environmental impact statement at the federal level, that the public is given information beyond what industry wants it to hear and beyond what government wants it to hear. They're given all of the facts so they can make an informed decision about whether the risks to human health and safety and environmental quality are outweighed by the supposed benefits of the pesticide.
So I'm just trying to get clear on the technicalities of the lawsuit. Prevailing in the lawsuit wouldn't necessarily mean no spraying. It would mean the pesticides had to go through an additional layer of review before they could be used as part of the spraying plan.
Well, it would mean that the TMAC pesticides would never be used because EPA has already classified TMAC as unsafe for use in agricultural and residential areas. It can't go back on that. It's based on thousands of data points, among them the ones from Santa Cruz and Monterey County. So that will not happen.
Wait, I'm confused. So EPA classified it that way and then exempted it from review later?
TMAC was classified as not permitted for use on food. Raw food, processed food, any food. That means tomatoes in your garden. oranges in your garden, agricultural fields. Most people, such as me, have little gardens in their yards. And spraying over urban areas, as in rural areas, would deliver this pesticide onto raw foods, and that's illegal.
But did EPA classify? Did they exempt it from review, or is this one of the inner ingredients? I'm confused what TMAC is.
TMAC is an inert ingredient, and EPA knew at the time that it purported to exempt these pesticides that it was one of the inert ingredients in them. It simply failed to follow the law. It failed to point out to the U.S. Department of Agriculture that it could not exempt these pesticides because they were unsafe.
So where does the lawsuit go from here?
Inside that door.
Sure, you file it. Do they have to decide to hear it?
Oh, they will hear it. The government may file a motion to dismiss, hoping that they can squash us like the bugs they like to kill, but they won't. We will prevail in this case. We will rise up and demonstrate why the checks and balances in our system of governance work brilliantly and provide guidance for agencies that lose their way and fail to follow the laws of this land.